This session, which is Constitution 101, Could They Do It Here? We are happy to welcome two respected speakers here. I want to welcome Margot Young, who is from BC. She's a professor at the Allard Law School at the University of British Columbia, and she's the director of the Social Justice Concentration. Without further ado, welcome and take it away.
Well, thank you very much. It's a real pleasure to be here in Edmonton on Treaty 6 territory. I know that land acknowledgements often appear to be somewhat rote these days, but I do think they're important to make, and I think for topics that circle around concerns to do with the health of democracies, it's particularly important to remind us all of the colonial past and ongoing legacy of the land that is now called Canada. I want to start by noting that the institution of judicial review in a democracy is often regarded as a deviant institution. And that's because it allows unelected judges to overturn the will of the majority as it has been expressed in legislation. And of course, that legislative expression is closely tied to the ballot box. And elections are, as you know, in our liberal democracy, one of the primary sources of the legitimacy of the exercise of power. And so the concern about the misfit, as it were, of judicial review on constitutional grounds in a democracy was a very common refrain at the time that the Charter of Rights and Freedoms was being considered, and it's really continued to be such, originally most strongly from the left, but now also particularly strongly from the right. Indeed, we've seen a kind of resurgence of critiques of judicial review on the basis of charter rights from a number of right-wing constitutional law and political institutions. But anyway, this idea of the concern about judicial review in a democracy really was one of the perspectives, or a strong strand or thread in the perspective that led to the inclusion of Section 33 in the Charter. And of course, Section 33 is the notwithstanding clause or the override provision. And in a moment, I'm going to show a slide of its text so you can get a more detailed idea about what it is. Now, it was argued that Section 33 was a kind of democratic safety valve that gives the government the last word when faced with what governments might find to be overreach or unfortunate conclusions about the scope or analysis of rights in the Charter. And here we have a copy on the PowerPoint of Section 33. Now, supporters of Section 33 defend the notwithstanding clause as moderating the impact of judicial decision-making. Section 33 has been named as a kind of counter-majoritarian, to the majoritarian difficulty or denial that results from charter-based judicial review. So Section 33, therefore, allows for the reassertion of majoritarian priorities as they have been articulated by the democratic process in the face of judicial reliance on charter rights to counter, to contradict, to undo a kind of majority political perspective in specific circumstances. It's also argued that the balance that Section 33 reasserts, that is the balance in favor of the legislative branch relative to the judicial branch, that balance is nuanced. So you can see up here, and I've highlighted the portions of Section 33 that are relevant to this point. You can see up here that there are elements to the use of Section 33 that to some extent, it's been argued, constrain its use. So there's a sunset provision, that is after 5 years, the use of the override or the override enactment will expire. You have to reenact it, that there's a limited scope to the override. It covers only the rights in Section 2 and in Sections 7 to 15. And there are a number of other formal, not substantive, but formal requirements that it is said encourage acute political notice and discussion that should accompany deployment of the override. So the argument goes then, as I've said, Section 33 gives the last word again to the legislative branch and consequently then to the democratic process. And it's done in a manner, it's argued, and this was clearly in the minds of the drafters when they put these features into the override, it's done in a manner that is structured, it's hoped, to ensure political discussion, debate, and response to the use of the override. And indeed, one could point to the public outcry that came at both the provincial level and the federal level when Ralph Klein initially passed legislation ordering the Ontario teachers back to work with the override provision attached. And in fact, the political outrage was so significant that I would argue it effectively short-sheeted that attempt by Premier Klein, and ultimately he withdrew the legislation. Now it's interesting, and this is important, we haven't seen that same kind of response, not to the same extent, and certainly not with the same result, to the case of Quebec's Bill 21, which is about legislation that bans religious symbols from employees or from the civil service. We haven't seen it in relation to the Saskatchewan government's legislation, the Parents' Bill of Rights, Bill 137 that limits or puts constraints on the choice of pronoun use by students in schools. And then we most certainly have not seen this kind of response with the result of the government withdrawing the legislation in terms of Alberta's four most recent uses of Section 33. I'll talk about these ultimately in a moment. But it is important to note that the examples of Section 33 use, they're not the only examples, but they are in some ways not only the most recent, but really the most indicative of a sea change in terms of resort to Section 33. These most recent uses target very vulnerable minorities. And I'm going to just bracket for a moment the reference to Alberta's teachers. I think there's some specific things to be said about that are a bit different from the use of religious symbols in Quebec's bill, and of course the constraints that are in Saskatchewan and Alberta's legislation of choices made by trans, two-spirit, and gender-diverse youth. These recent uses target very vulnerable minorities, and I don't think that's purely coincidental to the fact that there hasn't been this strong tide of opposition. There's certainly been opposition, but we haven't seen it the way we saw it with Ontario's treatment of teachers. And we know, for example, that these are very vulnerable groups. So with respect to trans people and to gender diverse individuals, the Supreme Court of Canada, for example, said very recently that they are groups and individuals that have a history of systematically denied equality. Now, in today's talk, I want to take on the understanding of the override as a kind of democratic bolster or injection into the Charter itself. I want to focus on rebutting the kind of positive character that has been assigned to the availability of Section 33, and actually that since 1982, when we saw the enactment of the Charter, has been largely assumed by many people, both commentators and the public at large. And the current picture we're facing really challenges this assumption of the democratic benignness, as it were, of Section 33, and I think it has to force some rethinking, certainly by the courts as well, about what's amounting to a just too easy and arguably frequent use or reference or resort to Section 33. But I want to start by doing this by making first a more general argument to sit in the background. I want to argue that the Charter can be a key player in, as opposed to a threat to, Canadian democracy. And that then is going to lead to my argument that easy overriding of Charter rights is profoundly destructive of Canadian democracy, not supportive of it. And I have to say, this is a kind of an odd argument for me personally or professionally to make, because I am a real critic of Charter rights as in some way dumbing down important political debates of really constraining the kind of transformative options activism faces, and really examples of the kind of co-optation of radical political endeavors by the liberal legalism that we see in our constitutional system. I do recognize that there is a lively and extensive debate about the relationship between judicial constitutional rights review, that notion of judicial review I put up initially on the slides, and the institutional foundations of constitutional democracy. Just to repeat the point I made, courts simply don't have a great record on the front in terms of transformative social justice results, and the charter rights that Section 33 allows to be overridden are really kind of the materials in terms of which the court has disappointed. And I guess one aside to this is, should we really be so concerned that Section 15 is not available? Because really, claims under Section 15 have seldom amounted to much effective or widespread change. But I'm going to argue that we should. Although I do want to recognize that constitutions and bills of rights, like our charter, reflect a variety of purposes. And we need to understand constitutions not merely as sort of formally structuring institutions of government, but through things like the Charter of Rights and Freedoms. Constitutions are aspirational, that they really do beckon in their best way to a better future. Some constitutions seek to simply maintain a status quo, and certainly we see that aspect in our Constitution, but I certainly think our Charter has aspirational elements as well. It speaks to the political communities that make up Canada, and also to the kind of polity or political and social life world that we want in Canada. It sets out things that collectively we decided, but also I think we've reasserted through people's attachment to and respect for the Charter. It sets out key values and principles. And many of the values that the Charter enhances relate to both minority rights and to democracy. And there's a key link, I think, between minority rights and the health of a democracy. At its best, the Charter provides not merely for equality, but also for key forms of self-development or self-governance. And so it's really only with the full rights of equality and the participation that social, material, and formal equality allows for individual Canadians, it's only under such full rights that, and this is paraphrasing political theorist Sheldon Wolin, that the democratic process can answer to all rather than simply to the elite. And this is, I think, a key insight at this moment in Canada, or certainly at this moment in this province. And while acknowledging Charles Taylor's reminder that rights alone are inadequate to protecting individual dignity, participation, inclusion, we have to say that a rich understanding of rights is also one that sees them as upholding participation entitlements. And those are some of the conditions on which democracy depends. So that's not all you need for democracy, but it's certainly an important foundation for democracy. So substantive freedoms, including self-government, are nestled in political equalities. That is, they require political equalities and they contribute to political equalities. And really, charter rights at their best speak to minimum conditions for these things. So rights are not merely barriers protecting individuals from the state, but at their best, they really are affirmative mechanisms that ensure participation in society and in democratic institutions. And we see our court failing on this count many times, but it's also true that there are a number of occasions where they recognize this. So early on in the life of the Charter, then Chief Justice Brian Dickson of the Supreme Court of Canada wrote, and here I'm quoting, The underlying values and principles of a free and democratic society are the genesis of the rights and freedoms guaranteed by the Charter. Now, we struggle to have our rights actually live up to that appraisal, but it's certainly what we reach for when we litigate rights under constitutional judicial review. And this notion of rights, which includes this idea of positive entitlements, has been confirmed by jurists around the world. So British scholar Sandy Fredman, who's really well known for the work she does on equality rights, insists that, and here's a quote from her, "The state's bedrock responsibility for the destitute can be seen as a wholly legitimate judicial intervention to further rather than counter democracy." And so you see this observation, for example, providing the link I'm trying to maintain between social and economic rights, between both formal and substantive equality rights, to a healthy democracy. And so we must think about the substantive best that constitutionally protected rights can provide. We need to shift our focus away from ruminations about the abstract understandings of the separation of powers to really more carefully attending to the consequences, the substantive, participatory, inclusive consequences of judicial review for individuals and groups. And so the emphasis shifts from what judges ought not to do, to stay clear of, rather to insistence on what they must do. And here we're starting to see the potential link between rights assertion and democracy. Formal and substantive rights ensure membership in the political community, where the electoral process would otherwise result in legislators simply being challenged to do other than prioritize the issues of an affluent and homogeneous majority. So they disrupt in important ways then, having resources given to, space made for these other voices. They disrupt the kind of majoritarian politics that is exclusive and unfair. So what's going on now? Well, the use of Section 33 for some time was thought to require extraordinary circumstances. That is, it would be invoked only to deal with egregious human rights abuses due to the individualistic or the conservative nature of judicial review. Instead, we're seeing now, I think one could argue, its use as itself a kind of human rights abuse. And I'm going to focus on the recent use of Section 33 in Alberta, but I want to also just briefly touch on its use in Saskatchewan, and in one instance in Quebec, Bill 21, and the religious symbols legislation. I want to preface by noting that for many years, apart from regular and early use by Quebec in relation to preservation of the French language, Section 33 has been assumed to lie dormant and really to be almost politically impossible to use. A lot of people actually argued there was kind of a constitutional convention against its use. It's never been used by the federal government, and its use across the provinces was scattered and intermittent. Well, now this picture has changed, and it's changing rapidly. The political restraint to date that allowed Canadians to be complacent about Section 33 appears to have simply dissolved. I'm sure you're all by now very familiar with the politics of Alberta in the last few weeks. Bill 9 was introduced into the Legislative Assembly, and when it's proclaimed, it will bring into force legislation that inserts notwithstanding clauses in 3 pieces of legislation. And those notwithstanding clauses will immunize, it's argued, the legislation from the import of Section 2 and Sections 7 to 15 of the Charter, the full range of the potential scope of Section 33. There's also, by the way, in the override provisions, overriding of the 2 variants of human rights legislation that are in force in Alberta. Okay, well, the legislation with these clauses inserted will collectively target, focus on the rights and the choices, the activities of two-spirited, trans and gender diverse youth, and in the case of amateur competitive sports, adults as well. So I've put the title up here to Bill 9 and the 3 statutes that it will amend. The Education Act, just to summarize them briefly, will require parental consent or notice for children and youth, there's some varying age limits in there, who want pronoun or name change in schools. The Health Professions Act will ban puberty blockers and hormone treatment for trans youth, and the Fairness and Safety in Sports Act will require evidence of sex identity at birth. So it will be limited participation in girls' and women's sports and amateur competitive arenas to cis women. And here's an example of a section of Bill 9 that shows the insertion of the notwithstanding clause into the Education Act. So the act is not long, it simply does what you see up here in relation to the Education Act to all three of the pre-existing statutes. And so once this act is proclaimed, it will effectively reenact those three pieces of legislation now containing the override provision. And of course, the political background, which I won't talk about, is that there are a number of legal challenges, two already and more being promised, to this legislation on the basis of Section 7, 15, and 2, I think they'll all be mentioned. So this is very similar to what the Saskatchewan government has done. And I also mentioned Quebec's Bill 21, where the same kind of clause was inserted to protect challenging on the basis of either Section 15 equality rights or religious freedom under Section 2A, given the impact in particular on Muslim women. Now, the Alberta government argues, well, all governments argue that they can do this, that they can immunize their legislation by simple insertion in this way of Section 33 into the legislation. And here in Alberta, the government has maintained that its actions are actually about protecting children. And you can see thus the Orwellian name of Bill 9, which is protecting Alberta's children, right? And this kind of legislation often has this sort of very loaded, politicized framing in its title. I think the message that these uses of Section 33 conveys is that the majority can impose its will on the minority anytime it pleases. Minorities in these cases, say Muslim women in the case of the Quebec bill, or trans or gender diverse people in terms of Saskatchewan and Alberta's legislation, are really threats to the democratic order rather than full participants whose equality status matters. Verinda Narain and I have written an article about the Quebec legislation, and she very aptly says that the Quebec legislation is about obliging contrarian groups to embrace the correct values as articulated by the majority. And the piece we wrote is for the Constitutional Forum, which is a local, really nationally important online law journal that comes out of the U of A. We argue in this place that in the face of illiberal, anti-pluralist, and nativist populism, the use of Section 33 by these governments really fuels a kind of democratic distemper by mobilizing popular majority bias and discriminatory opinions. The recent resorts to Section 33 reinforce the constant possibility of overriding rights, and it adds weight to the assumption that overriding rights is viable and legitimate, and that rights observance is somehow merely optional. It communicates a message that the Constitution empowers governments to simply correct minority ways of life. And so the use of override in these circumstances operates ideologically. It shapes popular understandings of who matters in the Canadian democratic constitution, who ought to have their issues and experiences put solidly and with respect on the political agenda. So I would argue it's a real hollowing out of our, not merely the effectiveness of the Charter, but the kind of pluralist democracy to which we ought to subscribe. And indeed, it will have an effect possibly on what courts do under the Charter. So faced with the possibility of the sort of looming invocation of Section 33, courts may be inclined to be more deferent to government legislation that is problematic in order not to trigger complete negation of a right by Section 33. The opposite has been what's been assumed about Section 33 up to this point, that it will actually encourage sort of courageous and brave and strong articulation of rights, because the government, after all, has resort to Section 33. But if we find Section 33 becoming regularly a tactic deployed by the government, we might see not merely a public tolerance for a less important charter, but also a judicial reading down of what the charter means in terms of really emphasizing the importance of difference, of diversity, to our democracy and to our society. But I want to just refer briefly in conclusion to some feminist democratic theorists who talk about healthy democracies involving a kind of democratic pluralism that affirms social group difference and that really provides a forum for the being together of strangers, not simply the effective community of the same. So it's a thick and fractious democracy that they envision, in which voice and participation of all, including those who are marginalized or subject to deep vulnerability, including the voices and participation, so that you have a kind of radical democratic pluralism. And it simply cannot be that we tolerate an evolution in the use of Section 33 such that Section 33 becomes a kind of bottomless pit where, to use the words of another legal scholar, rights go to die. And when we're in the kind of political circumstances in which you're in, we need to be clear about what charter rights can do, how they might stand as beacons of light in a current dark and hateful political environment. Now, ironies abound. To circle back to my starting point, democracy sits uneasily with judicial review, but in moments like now, when democratic impulses fail at the political level, perhaps charter rights really are necessary. There are, after all, many points of pressure on democracies, not just the institution of judicial review. Judges don't do their jobs under the charter perfectly. They too fall short of powerful articulations of social justice. But in times of demagogic populist governments, the liberal commitments, and I'm a great critique of the liberal commitments that constrain charter rights. Perhaps now, though, however, the liberal commitments of the charter cannot be discounted. Leapfrogging this protection by use of Section 33 has to be deeply concerning. We have to be clear about how an inclusive, diverse Canadian democracy is put under threat by undermining vulnerable minorities' right to rights. Thanks, everybody.
Thanks so much. That was it's a massive subject that you condensed down to 30 minutes. I'm sure you could have gone on for quite a bit more time. Next, we would like to welcome Rebecca, and I'm going to do my best here. Macias Gimenez. Macias Gimenez.
So my name is Rebecca Macias Gimenez. I'm an assistant professor in the Faculty of Law here at U of A. I've been here for 3 years now. I did my PhD at UVic, but I'm originally from Brazil. I've been in Canada for 10 years. And I teach here at U of A. I teach constitutional law, and I teach courses related to Indigenous peoples and Indigenous rights and Indigenous legal orders. So today I'll be talking about 3 important concepts. So one, the concept of sovereignty. Second, the honor of the crown. And the third one, not so much a concept, but a legal instrument that now is part of Canadian law, which is the UN Declaration on the Rights of Indigenous Peoples. So taking all that into one basket, what can happen in the future? So what paths can be taken in terms of Indigenous rights and recognition of Indigenous legal orders in Canada? So I'm speaking from this liberal legal system that we live in, but also acknowledging that there are many Indigenous legal orders that operate in what we now call Canada. What I mean in reality is that we live in this, and we are trying to coexist with many legal orders, including Canadian legal system and Indigenous legal orders. And I believe that the honor of the Crown, which is an unwritten constitutional principle coming from British common law tradition, is one legal principle that can help us in this coexistence of legal orders and recognizing different sovereignties and overlapping those sovereignties. And in addition to that, the UN Declaration on the Rights of Indigenous Peoples as part of Canadian law today can help us in this process. One problem, though, is that the honor of the Crown is actually a baby of Crown sovereignty. So the honor of the Crown is a child of Crown sovereignty. It was born from Crown sovereignty. I don't know if any of you here have teenage kids. I have a teenage girl, and we clash a lot. She challenges me. She was born from like me, and but we do clash a lot. And she has her own views of the world, and she wants to persuade me and convince me in a lot of different things. And I'm very grateful to that. So here I'm going to use this example as, you know, the honor of the Crown as a child of Crown sovereignty, this centralizing concept of, you know, the state having control over a territory. But the honor of the Crown can also take different shapes and different forms, and it can challenge the concept of sovereignty. So that's the focus of my presentation today. So my plan for today is that I will talk a little bit about Crown sovereignty, what that means, what is that concept, and how it has affected Indigenous peoples in Canada. The concept of the honor of the Crown, or the principle of the honor of the Crown, and what the courts have been saying about the honor of the Crown, and how that applies to the duty to consult and accommodate, and how the doctrine of the duty to consult and accommodate has been consolidated in Canada and evolving and changing, especially now with the UN Declaration on the Rights of Indigenous Peoples. There are some new interesting cases that I think can serve as indicators to where we can go in terms of overlapping sovereignties. The question, can the honor of the Crown, helped by the UN Declaration on the Rights of Indigenous Peoples, challenge this centralizing concept of sovereignty? So this will be a more positive approach to the issue, even though, of course, many Indigenous peoples might not agree with me, and they might say, you know, like, this is not about sharing sovereignty, this is not about overlapping sovereignty. We have always been sovereign in this territory, and we would like to continue to be so. But as I said, this is an attempt to coexistence, right, of the state law and Indigenous people's laws. So I apologize for the wordy slides, and I'm going to try as much as possible to kind of translate what the courts have said and what legal scholars have said about sovereignty. So I start with John Austin, a legal philosopher from the 19th century, with this very centralizing idea of sovereignty, right? Sovereignty is the power of one individual or one entity that obeys no one, right? No one is ruling that sovereign. And all the power to make laws and to apply laws, they are concentrated on that entity or on that individual. The courts have addressed the problem of sovereignty, right? As we've heard before, terra nullius was a concept, and the doctrine of discovery was a concept that was used by European countries to be able to assert their sovereignty in North America. Nevertheless, the Supreme Court and lower courts, they have said that the doctrine of discovery and terra nullius they do not apply to Canadian law anymore. So they're not the foundation for the Crown being able to say, we are sovereign over this territory. So then now we have this issue. What is then the foundation of Crown sovereignty, right? So courts have said that the Crown asserted sovereignty when they came to North America, but they recognized the prior occupation of Indigenous peoples. And now what Section 35 of the Constitution is trying to do is to reconcile this prior occupation of Indigenous peoples with the assertion of Crown sovereignty. So that is the court's vision of reconciliation, right? It's not dismissing Crown sovereignty, it's not deconstructing Crown sovereignty, it just wants to reconcile it with the prior occupation of Indigenous peoples. And it is a de facto sovereignty, meaning that it is not a completely legal, perfectly legal concept. It means that the Crown is perfecting its sovereignty over time through mechanisms such as treaty negotiation, title recognition, and the duty to consult and accommodate, right? So that means that sovereignty is not a de jure, it's not legally valid. It's assumed sovereignty, right? So this tension gives rise to a special relationship with Indigenous peoples, a relationship that is based on the honor of the Crown. So in every instance, in every moment that the Crown has a relationship with Indigenous peoples, they must act honorably. So what does that mean, the honor of the Crown? So as I said, the honor of the Crown is a concept that comes from British tradition, from medieval times, that said that the king can't do any wrong. So it's not possible for the king to make mistakes, to do wrong, to be unfair, right? So that's the origin of the principle. So that principle, and very recently in case law, the court said that the principle refers to servants of the Crown that must conduct themselves with honor when they're acting on behalf of the sovereign. What does that mean, right? So scholars have critiqued this concept or this principle as being very vague and with not much teeth, right? And the court has also said that it is assumed that the Crown always intends to fulfill its promises. So as you can imagine, that has been used many times to justify past wrongs that the Crown has done, right? It's not that the Crown is always acting in the best interest of Indigenous peoples, is that when they don't, their actions are justified by this principle of the honor of the Crown. So the honor of the Crown serves as this balancing mechanism between like the sovereign power of the Crown and the interests of Indigenous peoples. So the duty to consult and accommodate is one of the duties from common law that stems from the honor of the Crown, right? It's not written in the Constitution. It's not written in Section 35 of the Constitution. It was developed by the courts, right? So the duty to consult was first articulated by the Supreme Court with the Haida decision in 2004. And in that decision, the court established, standards for that consultation. Some scholars have really focused on the duty to consult and accommodate, and they put a lot of hope on it, and they really rely on the duty to consult for this, like scholars, like for example, Richard Stacy, that says that the duty to consult can erase the sovereignty deficit that exists today, right? This problem of legitimacy that the crown has because it has no foundation for the sovereignty concept, that this problem can be erased by the duty to consult. And I really don't agree with that approach. So the duty to consult, as I said, was first articulated in Haida, and they affirmed that the honor of the crown comes from crown sovereignty, and it has the purpose of reconciliation. So I don't know if you find it contradictory. I do. Every time that I read that the honor of the crown comes from sovereignty, and its purpose is to promote reconciliation, right? But remember that the vision of reconciliation that the court first proposed is the reconciliation between the prior occupation of indigenous peoples with the sovereignty of the crown. So if we're speaking of that reconciliation, maybe it is serving its purposes, right? The crown may act based on this doctrine of the duty to consult. The crown may act even in face of disagreement, right? So we all have heard that the duty to consult and even consent doesn't mean that indigenous peoples have a veto power over proposals by the government or industry, right? So veto is something that's out of the table. So the only entity that needs to be satisfied by the process of consultation and accommodation is the crown itself, right? Indigenous peoples and legal orders don't need to be satisfied for the government to go ahead with their proposals. Okay, so you probably have heard many critiques about that. And then the UN Declaration on the Rights of Indigenous Peoples enters into Canadian law. As you might know, the center of the UN Declaration on the Rights of Indigenous Peoples is the right to self-determination, right? And as part of the right to self-determination is the right to self-govern. So Indigenous peoples would have the right to self-govern. But just as the Canadian law has, from the Sparrow decision, it has the possibility that the Crown infringes on Indigenous rights and justify that infringement. Also, the UN Declaration has in its Article 46 the possibility of states limiting Indigenous rights. So keep that in mind. So there's a discussion going on in the courts about whether the UN Declaration is just an interpretive lens or an interpretive aid for courts to apply Canadian law or state Aboriginal law to cases, or if the UN Declaration can actually be a source of law, if judges can actually draw from the provisions of the UN Declaration in making their pronouncements, right? So there were cases in which, for example, in British Columbia, in Gitsala, in 2023, the court said, oh, it's just an interpretive aid, and I cannot use it, and I cannot apply it directly here because we don't have any guidance from the Supreme Court. That's what the BC court said. But since then, other Supreme Court decisions are important for us to know what is actually the role of the UN Declaration in Canadian legal system. So in the reference regarding Bill C-92, which is the act respecting First Nations, Métis, Inuit, children, youth, and their families, the Supreme Court said that the UN Declaration serves as a framework for reconciliation in Canada, right? So if we're talking about the reconciliation, the framework for reconciliation, we have to go back to that concept of reconciliation. What is reconciliation, right? In another decision, the Dixon decision, so the court stated that now that the UN Declaration on the Rights of Indigenous Peoples is part of Canadian law and the UN Declaration recognizes the inherent the right to self-government of Indigenous peoples. That is also part of our Canadian law. And in a very interesting decision earlier this year called the Quebec decision, which is about the proposal of a nuclear waste management facility in Quebec. For the first time that I'm aware of, a federal court applied the UN Declaration as actually a source of law. So they really took out of the provisions of the UN Declaration, and those provisions are regarding the free, prior, and informed consent, and they applied that to the decision. So they said that the free, prior, and informed consent should be applied to enhance the duty to consult. But still, they were pretty clear that it doesn't mean that Indigenous peoples have the right to veto a certain proposal. But they did say that it's required for the government to seek Indigenous peoples' consent. The scope of the duty to consult might be increased. Having said all that, can the honor of the crown is that measure stick that's used in consultation and accommodation to say this consultation was done properly or this consultation was not done properly, right? And as I said before, the honor of the crown only has to satisfy the crown, not necessarily Indigenous governments. But there has been a shift in the language that's being used by the court. In that decision that I just mentioned about the nuclear waste facility, the Quebec decision, the federal court said the doctrine of reconciliation seeks to reconcile the pre-existence of Indigenous society with the imposition of Crown sovereignty. So something about the language has changed, right? In another decision, this time by the Supreme Court, regarding the honor of the crown, the Takuikan decision in Quebec, the court said that the honor of the crown and the obligations flowing from it are part of the public law governing the liability of the state. So they made clear that the honor of the crown is there to keep the government accountable. And the failures to comply with these obligations requires the crown to restore the nation-to-nation relationship that was damaged by dishonorable conduct. And here, let me just pause. The nation-to-nation relationship is, a term that we've heard a lot, right? Especially in the Justin Trudeau era. He really liked to use that term, nation-to-nation relationship. At the same time that he really relied on consultation, like in the Trans Mountain Pipeline, to impose government policies. So if you remember, the consultation that was done during the Trans Mountain Pipeline really didn't lead anywhere, and it was just repeated, and then the government went ahead with the project. But the court also said in another case recently decided by the Supreme Court regarding treaties in Ontario that the honor of the crown is not a mere incantation, meaning like it's not that just simply that vague concept, but it's a core concept that finds its application in concrete practices and give rise to different duties in different circumstances. So recently, the Supreme Court has said, there are concrete obligations that come from the honor of the crown. The obligation to diligently implement treaties, the obligation to negotiate with Indigenous nations, fiduciary duties, and also the duty to consult and accommodate. What does it mean today? Like, is it possible, considering all that, is it possible to think of a future where we have shared sovereignty or overlapping sovereignty? So as I said, the Supreme Court affirmed, the UN Declaration is a framework for reconciliation. Again, there's a change in the language, like in this other case, the Montour decision in Quebec, decided by a court in Quebec, said that the reconciliation vision that lies behind Section 35 should not be seen as a means to subjugate Aboriginal peoples to an absolutely sovereign crown, but as a means to establish the kind of relationship that should have flourished since Confederation. So going back to those peace and friendship treaties that were signed before Confederation, and thinking that is the term, that is the framework of the relationship that should have happened across Canadian history. And I really like how my colleagues, Josh Nichols and Rob Hamilton, how they describe that since those peace and friendship treaties that happened in the 1700s, 1800s, there was a thickening of crown sovereignty through courts' decisions, right? And then I'm wondering if now we can see a thinning down of that concept of crown sovereignty with the UN Declaration on the Rights of Indigenous Peoples. Really trying as much as I can to take a positive approach. I think we can think of this shared future. At least I think we should act on that. Taking from Professor Tully, a mentor of mine, like we should act on the vision that we would like things to be, the reality to be, right? So I see some practical things going on. I see Indigenous peoples revitalizing their Indigenous legal orders, and colleagues of mine like Professors Val Napoleon, Hadley Freeland, Aaron Mills, Darcy Lindbergh, supporting those Indigenous communities in articulating what their laws are, and even sometimes formalizing their laws, formalizing their constitutions. There's also the need for the Crown to recognize and implement their fiduciary obligations. So like basic things like clean water, human rights, like clean water, housing, funds for child welfare and things like that, over-incarceration issues that need to be addressed. A really interesting concept that was developed by Professor Naomi Metallic, which is called legislated reconciliation. And the government is picking up on this concept, and the courts are as well, using the powers that the federal government has over Indigenous peoples and Indigenous lands from the Constitution of 1867, and using that to open spaces for Indigenous self-government. So if, for example, the Bill C-92 that I mentioned before, the one referring to Indigenous children and their families' welfare, there is a paramountcy clause that says that laws of Indigenous communities, they are paramount. So they override even federal laws and provincial laws in regards to welfare to Indigenous children. There's also the UNDRIP legislation that was enacted by Parliament, the Interpretation Act, that's part of this bundle of laws that the government is supporting. Also, there's a renewed interpretation of treaty rights. So in British Columbia, the BC Supreme Court decided on a case about treaty rights, opening spaces for Indigenous peoples to co-develop frameworks for environmental decisions and how permits are issued for industrial development. Also, cases regarding interpretation of historic treaties, and here in Alberta, a number of First Nations are also in court making those claims that number treaties need to be correctly interpreted to incorporate Indigenous jurisdictional power over lands and resources. Title recognition. So you might have heard that there was a recent court decision in British Columbia that recognized title to the Cowichan tribes. This decision is being in the media a lot. People with the fear of their fee simple of properties being affected by it, which is totally unfunded concern. But one thing that is really part of my area of research, which is regarding the environment and impact assessment. The new Impact Assessment Act of 2019, which the conservatives, and I really I can hear Pierre Poilievre saying, "Oh, this is a terrible legislation. It creates a lot of red tape for projects to develop our country, to economic growth." But that legislation opened up a space for Indigenous peoples to have governing bodies that participate in the impact assessment of projects or regional assessments since the beginning, since the planning stage, and they would have a more say in how the process is designed, even though they still don't have that veto power that's so much discussed in the courts. I think there is a range of practical things that are happening that are not necessarily shared jurisdiction or shared overlapping sovereignties, but they are indicating that a path forward is possible, right? And of course, I don't want to take any of that for granted because it's so much based on legislation and what the courts are saying. Things can shift, right? And there are many setbacks that Indigenous peoples have been experiencing, but I think we can kind of see a light somewhere at the end, and we can dream as shared sovereignties being operating in practice. Thank you.
Thanks so much. And why don't we start with this gentleman in the green right on the corner?
My question's for Rebecca. I really like the way you ended with the sort of potential or maybe emergent of something like shared sovereignty or treaty federalism being renewed. The question I have is that in all those examples of potentials like impact, shared decision-making, legislative reconciliation, Alberta is nowhere to be found. And even in the Bill C-92 decision, their submission to the reference case denied inherent jurisdiction. So I wanted to ask maybe if you had thoughts about that. The other question is the state is a capitalist state. So I'm curious about what the conditions of sharing would be in light of that component.
Yes, so Alberta is nowhere to be found. So I'm actually developing a short grant research about how Alberta has been sharing jurisdiction with Indigenous peoples in issues regarding environmental decision-making, like impact assessment, land use plan, regional assessment, strategic assessment, agreements with First Nations, and there is nothing. So the land use plans that we have today, there's consideration of Indigenous peoples through consultation processes, but not really substantial sharing of authority or jurisdiction. Your question about capitalism, I think we take for granted that democracy is just this democracy that we're living today, like the liberal understanding of democracy, and there are other forms of democracy or families of democracy as we're engaging with in a special issue that we're writing together, I think with Phil. The issue is not just creating processes, but acknowledging that other forms of democracy exist, and Indigenous peoples, as historically for millennia, have those democratic systems that we can learn a lot from. I agree with you. It's a matter of, our democracy is based on a capitalist system where extraction is kind of central to it. So how do we shift that? I don't know. But stop extracting. It's formed by all of us, right? So I think we can push forward for this type of recognition and be good allies to Indigenous peoples and keep the courts and the government in check. I don't have any more ideas on how we should do that.
I think the question was really to Rebecca, but I'm reading an interesting book right now by Nancy Fraser on vampire capitalism. And it sort of touches on these issues of the sort of internal incoherence but destructiveness as well of the current brand of capitalism we're experiencing in the 21st century and the different stress points that parallel, from my perspective, a very key issue, which is the range of inequalities and the kinds of group tensions across equal representation and inclusivity.
Yeah, if I just to add to that, there are many Indigenous scholars that have written about, extractivism and capitalism as a monster from the Cree and the Anishinaabe traditions, the Wedigo, just, eating up not just resources, but people and our future. So I think it's a discussion of principle, right? Not just of laws and politics.
It's a discussion of economic and political forms of organization, and that's a great connection you made because, of course, the images of a capitalism that is always voraciously hungry for more and this eternal, inevitable growth that it depends on.
Actually, I had a question for both Margot and Rebecca. For Margot, you mentioned majority bias in terms of use of the notwithstanding clause, and I would suggest perhaps in Alberta, the use of the notwithstanding clause may actually be a minority bias versus a majority bias in terms of who, the tail wagging the dog. So that's for Margot. For Rebecca, you said that the Crown's obligation is to seek consent. The legal obligation is to seek consent. But if in the end they do not get consent, my understanding would be that they have the ability to just override. So I raise that in terms of the current speculation about Danielle Smith and her desire for a pipeline, which, as I understand it, would require virtually stamping on the rights of Indigenous people, not just in this province, but in BC as well. Mm-hmm. And at the end of the day, is that the case, that the request would be from our Premier that you disregard Indigenous rights and concerns and the environment for the supreme goal of a pipeline? And they have the ability to do that.
So what I meant by majoritarian bias is the way in which majority will is reflected in the formation of the government. So I don't know what the polling data are about the current suite of notwithstanding clause-affected legislation and the actual issues, substantive issues, but it is clear that the Danielle Smith government represents a majority of voters through the electoral process. So that's the context in which I was using majoritarianism.
Yeah, about the veto question, I think I agree with you. If we're talking about overlapping sovereignties, and if one of the sovereignties has a veto power and the other doesn't, are we really talking about overlapping or sharing sovereignties? I don't think so. So the court has said, like in some circumstances, the duty to consult may amount to a duty to seek consent, but consent doesn't mean veto. And, when we teach that in law school, students are really confused because, that's the definition of consent, right? And if we're talking about, for example, sexual assault cases, if we ask, did you consent, right? That is, did you say yes or no? There are a number of scholars that have been, writing about that and really justifying, if you have a process that really considers Indigenous law and has a very deep dialogue, even though the result is not what the Indigenous nations wanted, that amounts to consent. I don't know if I agree with that. I think that's a very procedural approach to things. I think it's much deeper than that. It's about really recognizing Indigenous peoples as legal and political systems.
Tell me if you think this is a useful addition, which is it's the notion of the veto, Indigenous peoples having a kind of veto that really alarms many of the people who are proponents of increased extractive industry and things like pipelines. And I would mention just in BC, there's a case of the LNG facility at the Squamish Harbor where their wood fiber has a bunch of flotels with thousands of workers on board, and the project was agreed to by the Band Council of the local Indigenous peoples, but not by a lot of the matriarchs and other activists within that community who are really concerned about what seems to be an unavoidable impact on Indigenous women and girls of sexualized violence from these man camps in close proximity. And so you do have splits within Indigenous communities as well over the extension of extractive industries. Does that sort of slide in nicely to your points as well, or am I off base somehow?
Yeah, there are many nations that have this economic focus
Yeah.
and are, taking the opportunity. And I understand, right? Like economic rights for Indigenous peoples is a really important
The
thing.
well-being of
Yeah.
the community, yeah.
Yeah, but I don't know if, the imbalance of power and economic power is real. So is that really a choice that they're making, or is that like simply a pragmatic
Yeah.
decision, to keep their communities alive and having the resources that they need? So I don't know, I can't speak for any community on that.
But your point you make about how important it is to take into account the context where there's very real economic deprivation and suffering and the impact that has on the ability to say no or the authenticity of saying yes.
Yeah.
I'm just wondering, is there any kind of public reflection in Alberta about the previous regime of prejudicial medicalization, so to speak, the supposedly mentally feeble, which happened under Bibleville Aberhart from 1935 to 1971, the social credit government, and the linkage between that practice, which was actually a form of domestic Nazism. Of course, as you know, Hitler copied the program for sterilization in Alberta started in 1935, with the current attacks on transgender identities and two-spirited people and so on. And I also want to look at the history of repression in Quebec, which goes back also to the 1920s, 1930s in terms of the great flirtation with fascism, the idolization of Mussolini, the impact of fascist ideology upon the Union Nationale government of Duplessis, and whether there's any kind of conversation in Quebec as well about the historical nature and repetitive nature, cyclical nature of these kinds of attacks on various minorities end up being demonized one sort or another. I personally think that it is really important to bring up these historical contexts so that people realize that these new attacks on various minorities are actually nothing new for these various provinces, including Saskatchewan, where, of course, the Ku Klux Klan was very dominant in the 1920s, 1930s.
Well, I'm not sure I can say it better than you have, which is to say there's a really strong history of racism in Canada, and it continues into the present, and that we do see vilification of vulnerable groups continuing on. And I would add to that list treatment of Japanese Canadians. In fact, there's a very good book just published by Eric Adams, who's a faculty member here at U of A, on treatment of Japanese Canadians. And so the history matters, and it puts in context any kind of false complacency about trusting the majority all the time. And in fact, those kinds of instances were raised as reasons why we need constitutional rights in the way they were brought into effect in 1982. I would just add that.
Well, thank you so much to both of you for your wonderful insights.
Thank you, everybody.